Memorandum of Law on Sovereignty and Rights, last edited 17 August 2019. All existing forms of government today are based on the single concept that all people are the property slaves of the state. Therefore all people, of such states, only exist to serve involuntarily the wants and needs of those states. This concept is the foundation of socialism, communism, monarchies, dictatorship and democracies. Note, the USA is a constitutional republic. The United States of America is the only nation in the entire world where the government is supposed to serve the people, consent of the governed, where the government is supposed to obey the people, not where the people serve and obey the government, aka specific performance. This realization had its roots under the Magna Carta, Great Charter, in England during the early 13th century. Unfortunately, that realization has been systematically undermined by monarchs, socialists, judges and lawyers, barristers, to the present time, to a point of near non-existence in England. Fortunately, those principles and realizations were carried across the Atlantic here to the United States of America. What we are experiencing today is a wholesale attempt by other nations, oligarchs, socialists, communists, Democrats and RINO Republicans, aka saboteurs, to undermine and destroy the only remaining nation holding to the rule of law principles of a constitutional republic. With hypocrisy typical of the left, making declarations of sanctuary states and cities constitutes an open, willful declaration of lawlessness. Thereby declaring contempt of all laws limiting their power and reach, yet wanting to only uphold any laws which expand their power and reach. This process, designed to overthrow our system of government, has not been sudden, not recent. Some of the beginnings can be traced to the end of our Civil War, aka the war between the states, where the losing side, aka pro-slavery politicians, immediately began plot to rebuild and regain their power and reach. Those processes has been almost imperceptibly slow yet exponential, rapidly accelerated under the recent Obama, aka Marxist, administration. The real opposition and resistance to President Trump is to restrain his ability to see and reverse so much of these decades of incremental destruction to our system of government, aka a constitutional republic. After all, President Trump surely must be a bad man, since he was worked to reduce the government from taking much of your hard-earned money. No? Well then, the Democrats must be the good guys, since they all want to take back what President Trump enabled us to keep and to take even more of our hard-earned money. No? Well, consider which political party always raises taxes, taking your money, and which political party tries to reduce taxes even while strongly opposed by the first political party. Let us now systematically examine what we are fighting for and what we stand to lose with references to judicial decisions attempting to clarify what it all means. Socialists, communists, and all advocates of big government who desire redistribution where they are benefiting by being at the front of the line of takers, will not like people to know what you are about to learn here. Carefully look this over and judge for yourself the facts as they are about to be set out before you on these pages. Also note that all of the promises being made by the Socialist Democrats have already been made in the past and can be found in the former 1936 Constitution of the USSR, and we all know how well that worked out for Russia. Russia needed a wall to keep people in. You may be able to find these two quotes from our Russian opponents, page 1 of 33. Lenin, the overripe fruit, quote 1954. First, we will take Eastern Europe, then the masses of Asia, then we will encircle the United States, which will be the last bastion of capitalism. We will not have to attack. It will fall like an overripe fruit into our hands. During his testimony before a Senate subcommittee in 1954, the Soviet defector Nicholas Goncharov attributed that quote to Lenin Nikita Khrushchev, the small doses quote 1960. We cannot expect Americans to jump from capitalism to communism, but we can assist their elected leaders in giving Americans small doses of socialism until they suddenly awake to find they have communism. Another translation has been, you Americans are so gullible. No, you won't accept communism outright, but we'll keep feeding you small doses of socialism until you will finally wake up and find that you already have communism. We won't have to fight you, we'll so weaken your economy, until you fall like overripe fruit into our hands. This was thought to have been said during the alleged shoe-banging incident at the United Nations General Assembly. If one carefully examines the activities of the Obama administration, one will find that the common agenda was to tax and regulate as much as possible so as to drive business out of the country, leaving behind massive unemployment and poverty, making people dependent upon government for relief. That is how socialism or communism takes hold of a nation. Like a parasitic fungus in a petri dish consuming all in its path while leaving destruction in its wake, aka scorched earth policy. Note that Bernie Sanders, a leading Democrat, originally was a registered socialist and while registered as a Democrat still is a socialist in mind and heart. Socialists, communists and all advocates of big government need people to believe that governments are sovereign so that those people will have a ship of state in which to captain, making all others their servants. In a kingdom, the sovereign ruled over his serfs and slaves. One can easily do an internet search to find Supreme Court decisions which show that the duty of the police is not to protect individuals but to protect and expand the power and reach of those municipal corporations, states and city who employ them, police. While this may be true, one must not forget the simple fact that, while it is not their duty to protect, some police officers do in fact protect individuals, and that is a testament to the quality and integrity of those few officers who wear those uniforms. The rest who only work to grow the financial and political profits only bring disgrace upon the way the public sees them. Government immunity in Land Court noted that when the government entered into a commercial field of activity, it left immunity behind. Brady v. Roosevelt, 317 U.S. 575, 1943, FHA v. Burr, 309 U.S. 242, 1940, Kiefer v. RFC, 306 U.S. 381, 1939. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. See Owen v. City, 445 U.S. 662, both Key v. Terry, 713 F2D 1404, but merely act as an extension as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. Thompson v. Smith, 154 SE 579, 583, Keller v. P.E., 261 U.S. 428, FRC v. G.E., 281, U.S. 464. Immunity for judges does not extend to acts which are clearly outside of their jurisdiction. Bowers v. Heisel, C.A. N.J. 1966, 361 F2D 581, Cert. Den. 87 S. Court. 1367, 386 U.S. 1021, 18 L. ed. 2D 457. See also Muller v. Wachel, DCNY 1972, 345 F. Sup. 160, Rhodes v. Houston, D.C. Nebraska. 1962, 202 F. Sup. 624 affirmed 309 F2D 959, Cert. Den 83 Street 724, 372 U.S. 909, 9 L. ed. 719, Cert. Den 83 S. Court. 1282, 383 U.S. 971, 16 L. ed. 2nd 311, motion denied 285 F. Sup. 546. Page 2 of 33. The high courts, through their citations of authority, have frequently declared, that, where any state proceeds against a private individual in a judicial forum it is well settled that the state, county, municipality, etc. waives any immunity to counters, cross-claims and complaints, by direct or collateral means regarding the matters involved. Luckenbach v. The Thekla, 295 F 1020, 226 Us 328, Leiters v. Lund, 32 F 2D 308. It is the duty of courts to be watchful for the constitutional rights of the citizen, and against any stealthy encroachments thereon. It may be that it is the obnoxious thing in its mildest and least repulsive form, but illegitimate and unconstitutional practices get their first footing in that way, namely, by silent approaches and slight deviations from legal modes of procedure. Boyd v. United States, 116 U.S. 616. Supreme Court. For example, the right of a citizen to travel upon the public highways and to transport one's property thereon, either by carriage or automobile, is not a mere privilege, which a city may prohibit or permit at will, but a common right, which she has under the right to life, liberty, and the pursuit of happiness. Thompson v. Smith 154 SE 579. Note: drive, driving, driver are commercial contractual terms while travel, traveling, traveler is a non-commercial term for the use of an automobile, not for hire, but simply locomotion from one place to another for purely personal reasons and therefore not subject to the Commercial Motor Vehicle Code as an act of transportation, an expression designating a commercial activity. Only commercial, contractual agreements can compel specific performance, aka the terms and penalties embodied in a contract. No statutory duty lies to apply for, or to possess a driver license for personal travel and transportation as defendant is not within the class of persons for whose benefit or protection the statute was enacted. Ruth v. Quinn. Courts also recognized that private travel is fundamental right. The right to travel on the public highways is a constitutional right. Tesh Lines v. Danforth. The right to travel is part of the liberty that a citizen cannot be deprived without due process of law. Kent v. Dulles 357 U.S. 116, U.S. v. Lobb 385 U.S. 475. The use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and the individual cannot be rightfully deprived. Chicago Motor Coach vs. Chicago, 169 Nay 22, Lagar vs. Chicago, 28 Nay 934, Boone vs. Clark, 214 SSW 607, 25 Am, Ur. First Highways Sect.163. Operation of a motor vehicle upon public streets and highways is not a mere privilege but is a right or liberty protected by the guarantees of federal and state constitutions. Adams v. City of Pocatello. The right of a citizen to travel upon the public highways and to transport his property thereon, by horse-drawn carriage, wagon, or automobile is not a mere privilege which may be permitted or prohibited at will, but a common right which he has under his right to life, liberty, and the pursuit of happiness. Slusher v. Safety Coach Transit Co. The claim and exercise of a constitutional right cannot be converted into a crime. Miller vs. U.S. 230 F 486, 489. The right to travel is part of the liberty of which a citizen cannot be deprived. Kent v. Dulles page 3 of 33. Here the high courts have put it even more clearly, where a private statute exists of which the intent is regulation of commercial common carriers, the particular agency enforcing that private statute, shall not apply it by trickery and deceit, to persons who are not noticed by the statute as persons regulated and taxed, nor should it permit any party to do so in violation of a person's right to stay out of compelled license, contract, when he is not a person subject to the statute. State v. Eberhardt. It's simple. Socialists get themselves elected to the legislature. Meanwhile, car wrecks, school shootings, bombed federal buildings, environmental degradation, the poor, the sick, the tired and hungry, give many a cause to the "there ought to be a law" mentality of our socialist saviors. Using the problem of the day as the platform for their mission, they socialists unshackle themselves from their constitutional constraints and legislate, piece by piece, their legal straitjacket which protects the liberties of the formerly free citizenry. Why the United States of America did away with that system of involuntary servitude under the system of penal codes, aka peonage, can be understood from the lessons of history which follow. UCC 1-201 General Definitions 27 Person means an individual, corporation, business trust, estate, trust, partnership, limited liability company, association, joint venture, government, governmental subdivision, agency, or instrumentality, public corporation, or any other legal or commercial entity. Summary: the rules of legal definition dictate that the proceeding represents only commercial entities. Church of Scientology v. U.S. Department of Justice, 612 F2D 417 at 425, 1979. The word person in legal terminology is perceived as a general word which normally includes in its scope a variety of entities other than human beings. CEG 1, USC. Section Para 1. Title 18 greater than Part 1 greater than Chapter 77 greater than Section 1590, the anti-peonage laws trafficking with respect to peonage penal codes, slavery, involuntary servitude specific performance, or forced labor compelled insurance. Comments added. This is why penal codes require uncoerced, uncompelled, written consent and yet deceit is used to compel and enforce them to give the false illusion of consent. Peonage defined peonage noun 1. Formerly, especially in Mexico, a person held in servitude to work off debts or other obligations. 2. The practice of holding persons in servitude or partial slavery, as to work off a debt, an alleged debt, or to serve a penal sentence, aka debtor's prison. CNJ Constitution, Article 1, Paragraph 13 Prohibition against imprisonment for debt in any action 42 U.S. Code Section 1994 Peonage abolished. The holding of any person to service or labor under the system known as peonage is abolished and forever prohibited in any territory or state of the United States, and all acts, laws, resolutions, orders, regulations, or usages of any territory or state, which have heretofore established, maintained, or enforced, or by virtue of which any attempt shall hereafter be made to establish, maintain, or enforce, directly or indirectly, the voluntary or involuntary service or labor of any persons as peons, in liquidation of any debt or obligation, or otherwise, are declared null and void. Rs. Section 1990. The creation and imposition of penal codes, aka black codes, were used by the Southern Democrats to steal back the reparations made to the recently freed slaves after the Civil War between the states. Page 4 of 33(1) should also include the kidnapping, armed robbery and extortion segments of Title 18 as with, USC Title 18 greater than Part 1 greater than Chapter 55 greater than Section 1201 kidnapping where the restraint poses a danger of serious injury, or where it involves involuntary servitude. The offense, defined in Section 707 to 721, is unlawful imprisonment in the first degree. This offense is a Class C felony, commensurate with 18 U.S.C. Sections 1581 et seq., which, enacted pursuant to the 13th Amendment, makes it a felony to hold or return a person to a condition of peonage, or to kidnap, carry away, or hold a person to be sold into involuntary servitude, or held as a slave. I.e., compelled, involuntary, specific performance Act 147, Session Laws 2008, amended Section 707 to 721 by making it a crime of kidnapping to intentionally or knowingly restrain another person with the intent to unlawfully obtain the labor or services of the person, regardless of whether a debt collection is involved. Conference Committee Report No. 3808. The 1914 case United States vs. Reynolds comes closest to today's problems. Alabama selectively prosecuted and convicted African Americans for minor crimes, imposed fines they could not afford, threatened incarceration if they did not pay, and then offered a way out. A private employer would cover the fine if the defendant agreed to repay the employer through labor. If the worker later dared to quit, he could be prosecuted and convicted again. The court struck down this system that kept a defendant chained to an ever-turning wheel of servitude to discharge the obligation. Note, simply including those who are not African Americans and substituting federal funding in the place monies from private employers does not make this practice lawful or less egregious. Search and read What's Wrong with Work or Jail and Get to Work or Go to Jail, Workplace Rights Under Threat by Noah Zatz, Professor of Law UCLA. Debtors' Prisons Are Back, https://www.latimes.com/opinion/op-ed/la-o-0408. USC Title 15 greater than Chapter 1 greater than Section 17. The labor of a human being is not a commodity or article of commerce. AKA slavery. No man in this country is so high that he is above the law. No officer of the law may set that law at defiance, with impunity. All the officers of the government, from the highest to the lowest, are creatures of the law are bound to obey it. U.S. v. Lee, 106 U.S. 196, 221 South, Court. 240, 261, 27 L. ed. 171a. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate, artificial persons and the contracts between them. SCR 1795, Penhallow v. Dones Administrators 3 U.S. 54, 1 L. ed. 57, 3 Dol. 54, and b. The contracts between them involve U.S. citizens, which are deemed as corporate entities. C. Therefore, the U.S. citizens residing in one of the states of the Union, are classified as property and franchises of the federal government as an individual entity. Wheeling Steel Corp. v. Fox, 298 U.S. 193, 80 L. ed. 1143, 56 S. Court. 773 Michigan v. Duke 266 U.S. 476 led. At 449. Police power extends only to immediate criminal threats to public safety, health, welfare, etc. California v. Farley 1971, which driving and speeding are not. Comments added page 5 of 33. If a person is arrested on less than probable cause, the United States Supreme Court has long recognized that the aggrieved party has a cause of action under 42 U.S.C. Section 1983 for violation of Fourth Amendment rights. Law enforcement officers cannot claim objective reasonableness in these actions. The law is clearly established regarding arresting and imprisoning a person in a civil debt matter where there is no probable cause. Pearson v. Ray, 386 U.S. 547, 87 S. Court. 1213 C. Santiago v. City of Vineland and Schneider v. Simonini, both N.J. below and, the Fourth Amendment prohibits a police officer from arresting a person without probable cause. Paff v. Kaltenbach, 204 F. 3D 425, 435 3D CIR. 2000 Urzayeva v. Foster, 134 F. Sup. 2D 239, 248–49 2001 holding involuntary civil confinement as a massive curtailment of liberty, is tantamount to the infringement of being arrested and can be made only upon probable cause, citing Vitek v. Jones, 445 U.S. 480, 491, 100 S. Court. 1254, 63 L. ed. 2d 552 1980, the Supreme Court ruled in Malley v. Briggs, that the mere fact that a judge or magistrate issues an arrest warrant does not automatically insulate the officer from liability for an unconstitutional arrest. Only where the warrant application is so lacking in indicia of probable cause as to render official belief in its existence unreasonable, will the shield of immunity be lost. Malley at 344–45. Where officers in fact know that they are holding an innocent person, even where they have a facially valid warrant for his arrest, plaintiff has a cause of action for false arrest. Gay v. Wall, 761 F2D 175 4th CIR. 1985. Every U.S. Court of Appeals that has addressed this issue, has held that motor vehicle code, penal codes are a common, commercial, and civil debt subject to all debt collection procedures under the Fair Debt Collection Practices Act. C. U.S. v. Luco, 269 F3D 64, 68–69 1st CIR. 2001 citations omitted and U.S. v. Parker, 108 F3D 28, 31 3rd CIR. 1997. Based on this fact, imprisonment based upon a debt is prohibited absent clear evidence of fraud, under every state's constitutions prohibiting imprisonment for debt. When speaking about sovereignty, one must be careful to remember that such a reference can only be applied to its application as it applies to individuals. When individuals congregate as a group, they enter into the condition of a corporate capacity. To be sovereign, by definition, is to not be dependent on any other power or economic weakness. Corporations, by definition, cannot be sovereign as they, first, are fictions, and second, are completely dependent on the will of their owners, thereby making corporations servants and never masters of their creators. Fiction of law pg 562 Black's 5th edition, an assumption or supposition of law that something which is or may be false is true, or that a state of facts exists which has never really taken place. The state is that great fiction by which everyone tries to live at the expense of everyone else. Bastiat, Claude Frederick, The Law, 1850. The individual, unlike the corporation, cannot be taxed for the mere privilege of existing. The corporation is an artificial entity which owes its existence and charter powers to the state, but the individual's rights to live and own property are natural rights for the enjoyment of which an excise cannot be imposed. Redfield v. Fisher in Hale v. Hinkle. The Supreme Court has pointed out how the individual has unlimited powers while corporations are artificial creations and have no rights or powers apart from privileges limited by the terms of its creation by its creator. In this manner so too is the state another corporation created by page 6 of 33, a constitution, contract and limited in its powers by those who have created that artificial entity. For the state, or its agents, to change or otherwise expand that contract would be as if individual humans could change themselves into birds of fish. Once created, the created is subject to the constraints of that creation and not superior to the creator. Consent of the governed in a republican form of government refers to the sovereign individual, not the group, mob, corporate embodiment, government. When governments speak of sovereignty, they are actually speaking of their own fiction having dominance over other fictions which they have created in their own image. The exceptions being when an individual relinquishes sovereignty in exchange for some corporate benefit, aka privilege, such as limited liability or government service. This has been covered extensively by the United States Supreme Courts, as will be illustrated with some of the following SCOTUS citations. A state, like a merchant, makes a contract. A dishonest state, like a dishonest merchant, willfully refuses to discharge it. Chisholm v. Georgia, at p. 456. With the exception of criminal acts which are actions involving damage and destruction of rights or property, only corporations have police departments, municipal and private. This can be easily seen by looking at the numerous unincorporated towns which do not have their own police departments. Corporations most often use their police departments as a means to generate revenue and less often as a tool for law enforcement. While such use of police powers is lawful when applied to those who have contractually agreed to allow such use, that use of police powers to generate revenue is unlawful when applied to those who have not agreed by contract to that use. Doing so constitutes force, fraud, coercion, extortion, and in many cases kidnapping, all of which are unlawful activities. Note that crimes entail an actual act of taking or the destruction of a right or property, whereas the absence of an act can only be found as a violation when it is applied under the authority of a contract compelling specific performance, aka a civil, contractual agreement to perform, aka servitude. To be compelled to perform against one's will constitutes involuntary servitude, aka slavery. Maxims of law relating to sovereignty, that would be people as individuals, from Bouvier's Law Dictionary Unabridged, 8th edition, quod meum est sine me aferi non potest. 1. What is mine, sovereignty in this case, cannot be taken away without my consent, pg. 2159, derivativa potestas non potest esse major primitive. 2. The power, sovereign immunity in this case, which is derived cannot be greater than that from which it is derived, pg. 2131 Nemo potest facere per obliquum quod non potest facere per directum. 3. No one can do that indirectly which cannot be done directly, pg. 2147 Quod per me non possum, nec per alium. 4. What I cannot do in person, I cannot do through the agency of another, pg. 2159 Notes, 1 Jenk. Cent. 251. 2 Wing. Max. 36 Pinch. Law, B. 1. C. 3, p. 11. 3 1 Eden 512 4 Co. 24b. 11 id. 87a. Party cannot be bound by contract that he has not made or authorized. Free consent is an indispensable element in making valid contracts. Alexander v. Bosworth, page 7 of 33, codifying the compulsion of involuntary servitude under penal codes, constitutes the restoration of a system known as peonage, which was thought to have been abolished long ago and remains unlawful to this day. The use of deception and deceit to conceal that fact does not make such codes lawful and constitutional. A written, uncoerced, signed contract must be in place before jurisdiction in personam can be granted. That is why proof of jurisdiction must be entered on the record before jurisdiction can be found to exist. A court may be said to have subject matter jurisdiction over any matter, but that jurisdiction may not be extended to apply to anyone who has not consented in writing, aka contract, uncoerced with full information, knowledge and understanding by the one signing that contract. To illustrate this point, one who is shopping in a Walmart store cannot be compelled to wear a Walmart uniform. Walmart cannot sell or paint the automobile of someone who is shopping in Walmart. Walmart does not have jurisdiction over that shopper. If that shopper does not purchase anything from Walmart, such non-performance cannot be used to penalize that shopper. Now if the shopper take a product from Walmart without paying for it, the entire dynamic changes. When one does and continues to demand and retain all of their rights, and, at no time voluntarily waived any rights, including, but not limited to the right to any and all trials by a jury of their peers. A jury that has been clearly informed of their right to first judge the law before entertaining the facts. A jury that has the constitutionally guaranteed right to revoke the consent of the governed as set forth first by the Magna Carta Great Charter and later reaffirmed and guaranteed by the Constitution of the United States of America. This is a process which allows the non-violent revocation of powers used by those agents of government who would otherwise conspire to overthrow the only nation in the world which is charged with protecting the rights and sovereignty of its people. The practice of jury nullification is such a peaceful and lawful exercise of the right of the people to revoke the consent of the governed in the management of their delegation of their sovereign powers to a corporate fiction of law government. All governments are fictions of law and have to tax others in order to exist and are therefore dependent upon those taxed and must destroy, kill or otherwise oppress those who might demand proof of the existence of government, a fiction at best. As with the King of England in 1215 AD. He was dependent upon the barons for the protection of his power. When they withdrew their protection, the king became powerless, aka was never actually sovereign, then nor at any time since. This is the fact recognized by the Bill of Rights and the Constitution of the United States of America. Even the states and commonwealths are devoid of sovereign powers as they have no wealth which has not been first taken or provided by the people who are the origin of wealth, authority and power of our nation. Any of which can be withdrawn at any time if so chosen. Such is the message repeated by the people who populate the Supreme Court of these United States of America. Bastiat, Claude Frederick, The Law, 1850. The state is that great fiction by which everyone tries to live at the expense of everyone else. This is what the courts have to say about oaths and law. Oath, Black's 6th edition devotes more than a whole page to the definition of law, but this part is the most striking. In Old English jurisprudence, law is used to signify an oath, or the privilege of being sworn, as in the phrases to wage one's law, to lose one's law. So, the foundational definition of law is oath. Other words with a similar meaning as oath include contract, agreement, covenant, treaty, pledge. So in essence, law is nothing more than a man's agreement to behave in a certain way, usually by some private or public contract. Even God's law is rooted in his covenants with Abraham, Isaac, and Israel. Such is the oath promise given by God to Noah after the great flood that covered the earth that he would never flood the earth like that again. God gave as a sign a rainbow appearing after a storm that would be the reminder of God's promise. Hello, out there Pope. Page 8 of 33. Therefore, if one is to be bound by some law aka oath, then where is that instrument attesting to the existence of said oath, aka signed agreement, aka signed contract? Perhaps this is why more and more municipal corporations are refusing to recite the American Pledge of Allegiance at the opening of its proceeding, as well as removing that same activity from the schools. Perhaps they should also be informed that as a direct result, no one is therefore required to obey any law, oath passed by these parties as well. The higher courts have often addressed the subject of government entities who would act against constitutional protections in specific terms known as swearing against their oath of office. To this, these courts have also been very specific in calling such activities treason. One could also refer to the slow, systematic destruction of constitutionally guaranteed rights in another equally specific term, espionage. Declaration of Independence, but when a long train of abuses and usurpations, pursuing invariably the same object, evinces a design to reduce them under absolute despotism, it is their right, it is their duty, to throw off such government, and to provide new guards for their future security. He, king, has made judges dependent on his will alone, for the tenure of their offices, and the amount of salaries. He, king, has erected a multitude of new offices, and sent hither swarms of officers to harass our people, and eat out their substance. Abraham Lincoln stated the following on February 12, 1865, "Our safety, our liberty, depends upon preserving the Constitution of the United States as our fathers made it inviolate." The people of the United States are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who pervert the Constitution. Boyd v. United States, 116 U.S. 616 Supreme Court. It is the duty of courts to be watchful for the constitutional rights of the citizen, and against any stealthy encroachments thereon. It may be that it is the obnoxious thing in its mildest and least repulsive form, but illegitimate and unconstitutional practices get their first footing in that way, namely, by silent approaches and slight deviations from legal modes of procedure. U.S. Constitution, Article 6 Section 1, Clause 2, this Constitution, and the laws of the United States which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. Supremacy Clause. U.S. Constitution, Article 6 Section 1, Clause 3, judges bound, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. U.S. Constitution, Article 6 Section 1, Clause 5, Oath of Office, the senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial. Quote, U.S. Constitution, Amendment 9, the enumeration in the Constitution, of certain rights, shall not be construed to deny or disparage others retained by the people. It is the constitutional duty of each judge or justice in the courts to make sure that they, and all others in the judicial branch, always strictly follow their constitutional oath of office. When a case is placed before the court, the judges or justices must first determine if they have constitutional authority jurisdiction to hear page 9 of 33 the case. If they have this authority, then they are also required to hear and determine the case strictly according to the original intent of the law, the appropriate constitution and then statutes, codes, regulations, etc. which are themselves constitutional. To do otherwise would, as Chief Justice Marshall said in Marbury v. Madison, be solemn mockery and, equally a crime. The intent of the legislators constitutes the law. Stewart v. Kahn, 11 Wall. 78 U.S. 493, 504. A vivid example here is where the intent of the amendment granting birthright citizenship was to be exclusively given, only to those recently emancipated after the Civil War. As can be understood from the debates prior to the veto override, foreign nationals and aliens, illegal or otherwise, were specifically excluded as well as others not subjected to the discrimination advanced by the Southern Democrats who were trying to revisit their losing that war, a bit like the same people are doing with President Trump today. War against oath aka the law, no state legislator or executive or judicial officer can war against the federal constitution without violating his oath, taken under Article 6 Clause 3 thereof, to support it, if the legislatures of the several states may at will annul the judgments of the courts of the United States and destroy the rights acquired under those judgments, the Constitution itself becomes a solemn mockery. The constitutional theory is that we the people are the sovereigns, the state and federal officials only are agents. Cooper v. Aaron, 358 U.S. 1. 3 L. ed. 2nd 5, 78 S. Court 1401 1958 U.S.C. Title 18 greater than Part 1 greater than Chapter 115 greater than Section 2381 Treason whoever, owing allegiance to the United States, levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death, or shall be imprisoned not less than 5 years and fined under this title but not less than $10,000, and shall be incapable of holding any office under the United States. All codes, rules and regulations are applicable to the government authorities only, not human creators in accordance with God's laws. All codes, rules and regulations are unconstitutional and lacking in due process. Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 F2D 1344, 1348, 1985. Title 18 U.S. Code Section 2381, which states, when in the presence of two witnesses to the same overt act or in an open court of law if you fail to timely move to protect and defend the Constitution of the United States and honor your oath of office you are subject to the charge of capital felony treason, and upon conviction you will be taken by the posse to the nearest busy intersection and at high noon hung by the neck until dead. The body to remain in state till dusk is an example to anyone who takes his oath of office lightly. Without that oath of office this Constitution is worthless. That's why we have you take that oath of office, so we know that you will honor that oath and our Constitution. A nation can survive its fools, and even the ambitious. But it cannot survive treason from within. An enemy at the gates is less formidable, for he is known and carries his banner openly. But the traitor moves amongst those within the gate freely, his sly whispers rustling through all the alleys, heard in the very halls of government itself. For the traitor appears not a traitor, he speaks in accents familiar to his victims, and he wears their face and their arguments, he appeals to the baseness that lies deep in the hearts of all men. He rots the soul of a nation, he works secretly and unknown in the night to undermine the pillars of the city, he infects the body politic so that it can no longer resist. A murderer is less to fear. Still evident, Marcus Tullius Cicero page 10 of 33. This is what the courts have to say about sovereignty. Cooper v. Aaron, 358 U.S. 1, 78 S. Court. 1401 1958. No state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. The constitutional theory is that we the people are the sovereigns, the state and federal officials only are agents. Juilliard v. Greenman, 110 U.S. and Perry v. U.S. 294 U.S. 330. There is no such thing as a power of inherent sovereignty in the government of the United States. In this country sovereignty resides in the people, and Congress can exercise no power which they have not, by their Constitution entrusted to it, all else is withheld. Nor the states, an unlawful or unauthorized exercise of power does not become legitimated or authorized by reason of habitude. Benny, 29 BR 754, 762 ND. Cal 1983. Solvency is essential to sovereignty. An insolvent state mired in perpetual debt holds no power, owes its very existence to those who hold their debt or might provide the means to escape such debt. An insolvent state is without power to act and deliver relief as well as having a lesser power to those who hold greater wealth over such a state. The function of money, currency, is to deliver the holding of wealth into the hands of those who would not have created such wealth. Constitution of the United States, Article 1, Section 10, 1789. No state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, make anything but gold and silver coin a tender in payment of debts, pass any bill of attainder, ex post facto law, or law impairing the obligation of contracts, or grant any title of nobility. Government does not have the sovereign power to grant titles of nobility, as government is a fiction of law, aka corporation. Entirely powerless without the consent of the governed to draw upon, just as the King of England found himself powerless when his barons refused to support him from attack in the early 13th century absent his agreeing to the Magna Carta, aka the promise to be fair, just and accountable to them. With the abolition of gold coin in the early 1930s and silver coin in the early 1960s and the copper coin in the early 1980s, the last vestige of state sovereignty was lost by this and the ratifications of the 17th 1912 and 24th 1964 amendments. All these subversive espionage actions were committed under a government controlled by the Democratic Party. States have no wealth, aka states are insolvent, no voice in government and therefore no sovereignty apart from the illusion which is allowed to persist while waiting for the left to take the final steps to destroy the only form of government designed to protect rights and freedom. In Europe, the executive is synonymous with the sovereign power of a state where it is too commonly acquired by force or fraud or both. In America, however, the case is widely different. Our government is founded upon compact sovereignty was, and is, in the people. Glass v. The sloop Betsy, 3 Ball 6. 1794. In the United States the people are sovereign and the government cannot sever its relationship to the people by taking away their citizenship. Afrayim v. Rusk, 387 U.S. 253 1967. Boyd v. State of Nebraska, 143 U.S. 135 1892. The words "people of the United States" and "citizens" are synonymous terms, and mean the same thing. They both describe the political body who, according to our republican institutions, form the sovereignty, and who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people, and a constituent member of this sovereignty. Page 11 of 33 U.S. Supreme Court, Wilson v. Omaha Indian Tribe, 442 U.S. 653 1979 I. And common usage, the term person does not include the sovereign, and statutes employing the phrase are ordinarily construed to exclude it. United States v. Cooper Corp., 312 U.S. 600, 312 U.S. 604 1941, Accord, United States v. Mine Workers, 330 U.S. 258, 330 U.S. 275 1947. Particularly is this true where the statute imposes a burden or limitation, as distinguished from conferring a benefit or advantage. United States v. Knight, 14 Pet. 301, 39 U.S. 315 1840. U.S. Supreme Court in U.S. v. Cooper, 312 U.S. 600, 604, 61 S. Court 742 1941. Since in common usage the term person does not include the sovereign, statutes employing that term are ordinarily construed to exclude it. This was repeated in U.S. Supreme Court in U.S. v. United Mine Workers of America, 330 U.S. 258-67 S. Court. 677 1947. In common usage, the term person does not include the sovereign, and statutes employing it will ordinarily not be construed to do so. Church of Scientology v. U.S. Department of Justice, 612 F2D 417 at 425 1979. The word person in legal terminology is perceived as a general word which normally includes in its scope a variety of entities other than human beings, CEG 1, U.S.C. Section Para 1. Yick Wo v. Hopkins, 118 U.S. 356 1886 held, when we consider the nature and the theory of our institutions of government, the principles upon which they are supposed to rest 118 U.S. 356, 370, and review the history of their development, we are constrained to conclude that they do not mean to leave room for the play and action of purely personal and arbitrary power. Sovereignty itself is, of course, not subject to law, for it is the author and source of law, but in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. And the law is the definition and limitation of power. It is, indeed, quite true that there must always be lodged somewhere, and in some person or body, the authority of final decision, and in many cases of mere administration, the responsibility is purely political, no appeal lying except to the ultimate tribunal of the public judgment, exercised either in the pressure of opinion, or by means of the suffrage. But the fundamental rights to life, liberty, and the pursuit of happiness, considered as individual possessions, are secured by those maxims of constitutional law which are the monuments showing the victorious progress of the race in securing to men the blessings of civilization under the reign of just and equal laws, so that, in the famous language of the Massachusetts Bill of Rights, the government of the Commonwealth may be a government of laws and not of men. For the very idea that one man may be compelled to hold his life, or the means of living, or any material right essential to the enjoyment of life, at the mere will of another, seems to be intolerable in any country where freedom prevails, as being the essence of slavery itself. In United States Supreme Court decision of Yick Wo v. Hopkins 118 U.S. 356, the Supreme Court agreed with the fact that flesh and blood people are sovereigns in their own right, not subject to legislative or administrative law. This United States Supreme Court decision was handed down before our legal system became nearly as corrupt as it is today in America. Sovereignty itself is, of course, not subject to law, for it is the author and source of law, but in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. Note: review oath equals law. Understand that one can not take an oath to oneself. Perry v. U.S. 294 U.S. 330. Kawananakoa v. Polyblank, 205 U.S. 349, 353, 27 S. Court. 526, 527, 51 L. ed. 834 1907. In the United States, sovereignty resides in people, not their fictions. Page 12 of 33. Kawananakoa v. Polyblank, 205 U.S. 349, 353, 27 S. Court. 526, 527, 51 L. ed. 834 1907. A sovereign is exempt from suit, not because of any formal conception or obsolete theory, but on the logical and practical ground that there can be no legal right as against the authority that makes the law on which the right depends. In the early days of this nation, most people followed God's laws. As a result, each man was blessed with sovereignty over his own affairs, a large measure of free agency. Unlike slaves or subjects, we became responsible for our own judgments, Leviticus chapter 18 verse 4, and became obligated to stay out of the courts of the ungodly. If each one of us is sovereign, then does not each of us have our own court? Don't we all possess the inherent right to settle our own disputes? Of course. Which brings us back to the question, how does someone else's court gain jurisdiction over us, our property, and the operation of our affairs? The Founding Fathers understood all that. At his 1801 inaugural, Thomas Jefferson said, "Sometimes it is said that man cannot be trusted with the government of himself. Can he, then, be trusted with the government of others? Or have we found angels in the form of kings to govern him? Let history answer this question." And he also wrote, I know no safe depository of the ultimate powers of the society but the people themselves, and if we think them not enlightened enough to exercise their control with a wholesome discretion, the remedy is not to take it from them, but to inform their discretion. Letter, September 28, 1820. Basically it comes down to this simple explanation originating from ancient times: sovereignty originated from the individual who was the strongest and most fearsome fighter of the land. That individual commanded and held the power to protect, create and take, under the power of the sword wielded by the hand of that individual. The power to create is the power to destroy. Since the sovereign power is the supreme power of the land, all other power is subservient to that power. The servant cannot command the master. Fictions cannot wield swords as they have no substance in reality. Just as in adulthood most of us learn that the boogeyman cannot hurt us. AFROYIMV, Rusk, 387 U.S. 253 1967. In our country the people are sovereign and the government cannot sever its relationship to the people by taking away their citizenship. Our Constitution governs us and we must never forget that our Constitution limits the government to those powers specifically granted or those that are necessary and proper to carry out the specifically granted ones. Legal tender cases, 110 U.S. 421 1884, also referred in Juilliard v. Greenman, 110 U.S. and Perry v. U.S. 294 U.S. 330, but be that as it may, there is no such thing as a power of inherent sovereignty in the government of the United States. It is a government of delegated powers, supreme within its prescribed sphere, but powerless outside of it. In this country, sovereignty resides in the people, and Congress can exercise no power which they have not, by their Constitution, entrusted to it. All else is withheld. There is no inherent sovereignty in the states as well. All for the same reasons. Chisholm v. Georgia, U.S. 2 Dol 419, 454, 1 L. ed. 440, 455 et Dol 1793, pp. 471–472. At the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but they are sovereigns without subjects, with none to govern but themselves. American Banana Co. v. United Fruit Co. 29 S. Court. 511513, 213 U.S. 347, 53 L. ed. 826, 19 Ann. C.A.'s. 1047. The very meaning of sovereignty is that the decree of the sovereign makes law. To be obeyed and followed by our servants, page 13 of 33 Lansing v. Smith, 4 Wend. 9 N.Y. 1829, 21 M. Dec. 8910 C. Const. Law Sec. 298, 18 cm. Dom. Sec. 3, 228, 37 C. Nav. Watt. Sec. 219, Nulls Sec. 167, 48 C. Warves Sec. 3, 7. The people of this state, as the successors of its former sovereign, are entitled to all the rights which formerly belonged to the king by his prerogative. Butchers Union Co. v. Crescent City Co. 111 U.S. 746 1884. Not one of the judges who then disagreed with the majority of the court denied that the states possessed the fullest power ever claimed by the most earnest advocate of their reserved rights, to prescribe regulations affecting the health, the good order, the morals, the peace, and the safety of society within their respective limits. When such regulations do not conflict with any constitutional inhibition or natural right, their validity cannot be successfully controverted. Ellingham v. Dye, 178 Ind. 336, 99 Nay 1, 231 U.S. 250, 58 L. ed. 206, 34 South Court. 92, Sage v. New York, 154 NY 61, 47 Nay 1096. A constitution is designated as a supreme enactment, a fundamental act of legislation by the people of the state. A constitution is legislation direct from the people acting in their sovereign capacity, while a statute is legislation from their representatives, subject to limitations prescribed by the superior authority. In Ray Duncan, 139 U.S. 449, 11 S. Court. 573, 35 L. ed. 219, Minor v. Happersett, 88 U.S. 21 Wall. 162, 22 L. ed. 627. Black's Law Dictionary, 5th edition, p. 626. The United States of America was established as a union of republican states in which the powers of sovereignty are vested in the people and are exercised by the people, either directly, or through representatives chosen by the people, to whom those powers are specially delegated. Spooner v. McConnell, 22 F. 939, 943. The sovereignty of a state does not reside in the persons who fill the different departments of its government, but in the people, from whom the government emanated, and they may change it at their discretion. Sovereignty, then in this country, abides with the constituency, and not with the agent, and this remark is true, both in reference to the federal and state government. Persons are not people. Glass v. Sloop Betsy, Supreme Court, 1794. Our government is founded upon compact. Sovereignty was, and is, in the people. The People v. Herkimer, 4 Cowan, N.Y. 345, 348, 1825. The people, or sovereign, are not bound by general words in statutes, restrictive of prerogative right, title or interest, unless expressly named. Acts of limitation do not bind the king or the people. The people have been ceded all the rights of the king, the former sovereign. It is a maxim of the common law, that when an act is made for the common good and to prevent injury, the king shall be bound, though not named, but when a statute as general and prerogative right would be divested or taken from the king, or from the people, he shall not be bound. No government, aka corporation, aka fiction of law, can be sovereign over a living, breathing, human being. Fictions of law have no real, actual, existence and as such have not an arm by which to wield a sword against a real living human being. No provision of the Constitution is designed to be without effect. Anything that is in conflict is null and void of law. Clearly, for a secondary law to come in conflict with the supreme law was illogical, for certainly, the supreme law would prevail over all other laws, and certainly our forefathers had intended that the supreme law would be the basis of all law, and for any law to come in conflict would be null and void of law, it would bear no power to enforce, it would bear no obligation to obey, it would purport to settle as if it had never existed, for unconstitutionality page 14 of 33 would date from the enactment of such a law, not from the date so branded in an open court of law. No courts are bound to uphold it, and no citizens are bound to obey it. It operates as a near nullity or a fiction of law. If any statement, within any law, which is passed, is unconstitutional, the whole law is unconstitutional. By Marbury v. Madison, 5 U.S. 137, 1803. For all time. This is what the courts have to say about fictions of law, aka corporations. Hale v. Henkel 201 U.S. 43, 74–75. We are of the opinion that there is a clear distinction in this particular between an individual and a corporation, and that the latter has no right to refuse to submit its books and papers for examination on the suit of the state. The individual may stand upon his constitutional rights as a citizen. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business, or to open his doors to investigation, so far as it may tend to incriminate him. His power to not contract is also unlimited. He owes no such duty to the state, since he receives nothing therefrom, beyond the protection of his life, liberty, and property. His rights are such as the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law, and in accordance with the Constitution. Among his rights are the refusal to incriminate himself, and the immunity of himself and his property from arrest or seizure except under warrant of law. He owes nothing to the public so long as he does not trespass upon their rights. Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. It receives certain special privileges and franchises, and holds them subject to the laws of the state and the limitations of its charter. Its rights to act as a corporation are only preserved to it so long as it obeys the laws of its creation. There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that the state, having chartered a corporation to make use of certain franchises, could not in exercise of its sovereignty inquire how those franchises had been employed, and whether they had been abused, and demand the production of corporate books and papers for that purpose. In Hale v. Hinkle, the Supreme Court has pointed out how the individual has unlimited powers while corporations are artificial creations and have no rights or powers apart from privileges limited by the terms of its creation by its creator. In this manner, so too is the state another corporation created by a constitution, contract, and limited in its powers by those who have created that artificial entity. For the state to change or otherwise expand that contract would be as if individual humans could change themselves into birds of fish. Once created, the created is subject to the constraints of that creation and not superior to the creator. Consent of the governed in a republican form of government refers to the sovereign individual, not the group, mob, corporate embodiment, government, aka democracy. Corporations engaged in mercantile equity fall under the purview of the state's admiralty jurisdiction, and the public at large must be protected from their activities, as they, the corporations, private or municipal, are engaged in business for profit and therefore may have access to financial resources well in excess of that of any individual. The government, by becoming a corporator, c. 22 U.S.C. 286e, lays down its sovereignty and takes on that of a private citizen. It can exercise no power which is not derived from the corporate charter. See the Bank of the United States vs. Planters Bank of Georgia, 6 ed. 9 Wheat 244, U.S. vs. Burr, 309 U.S. 242. The real party in interest is not the de jure United States of America or state, but the bank and the fund. 22 U.S.C. A 286, ed. Seq. Crs. 1160-103. The acts committed under fraud, force and seizures are many times done under letters of marque and reprisal, i.e., recapture. See 31 U.S.C. A 5323. Page 15 of 33. Such principles as fraud and justice never dwell together, Wingetz's Maxims 680, and a right of action cannot arise out of fraud. Broom's Maxims 297, 729, Cowper's Reports 343, 5 Scott's New Reports 558, 10 Mass. 276, 38 Fed. 800, are too high of a thought concept, as is due process, just compensation, and justice itself. Honor is earned by honesty and integrity, not under false and fraudulent pretenses, nor will the color of the cloth one wears cover up the usurpations, lies, trickery and deceits. When black is fraudulently declared to be white, not all will live in darkness. The government is acting in a business capacity. Penhallow v. Doan's Administrators, 3 U.S. 54 1795 at page 93. Inasmuch as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance, is foreclosed from creating and attaining parity with the tangible. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate, artificial persons and the contracts between them. I.e., an uncoursed contract must be proven to exist giving consent. Summary, Penhallow v. Doan's Administrators, 3 U.S. 54 1795 at page 93, a distinction was taken at the bar between a state and the people of the state. It is a distinction I am not capable of comprehending. Summary, Rodriguez v. Donovan, 769 F2d 1344, all codes, rules and regulations are unconstitutional and lacking in due process. Redding v. Los Angeles 1947-81 SAW 2d 888, 185 p2d 430, APDISMD 334 US 8 2592, L. ed. 1754, 68 S. Court 1338. As a member of a corporation, a government never exercises its sovereignty. It acts merely as a corporator, and exercises no other power in the management of the affairs of the corporation than are expressly given by the Incorporating Act. The government, by becoming a corporator, lays down its sovereignty so far as respects the transactions of the corporation, and exercises no power or privilege which is not derived from the charter. Classic theory posits that there are three qualities of a legal fiction: falsity, utility, and dangerousness. To qualify as a legal fiction, a statement must, first of all, be false. 1. It is said to be a common feature of every legal fiction, that it states an apparent falsehood. 2. To use Bentham's definition, a legal fiction is an assumed fact notoriously false, upon which one reasons as if it were true. 3. The most useful test for falsity, in this regard, is to ask whether the statement asserts or implies a fact that would be regarded as false by an ordinary layperson, standing outside the legal system and looking in sort of an emperor's new clothes test. American Law and Procedure, Vol. 13, page 137, this word person and its scope and bearing in the law, involving, as it does, legal fictions and also apparently natural beings, it is difficult to understand, but it is absolutely necessary to grasp, at whatever cost, a true and proper understanding to the word in all the phases of its proper use. A person is here not a physical or individual person, but the status or condition with which he is invested, not an individual or physical person, but the status, condition or character borne by physical persons. The law of persons is the law of status or condition. What should now be obvious is that all people are sovereign and that all government is servant to the people, since all governments are corporate fictions of law. So where does government get its claim of sovereignty? Simple, government is only sovereign over, and has authority, that which it has created, such as corporations and individuals who have contracted away their sovereignty, aka status, in exchange for. Page 16 of 33 some form of privilege such as limited liability or other agreement with government to look the other way in matters where the licensed individual had done wrong, or in the more common case, where the individual can be prosecuted for doing nothing wrong at all, as in the case of motor vehicle codes. People can exist absent government, but government cannot exist absent people, no more than a dream can exist absent the dreamer. The dreamer can dream alone, but government cannot exist alone or even as a creation of only one individual. This is what the courts have to say about travel, aka driving. Americans' freedom to travel throughout the United States has long been recognized as a basic right under the Constitution, according to multiple cases including Williams v. Fears, 179 U.S. 270, 274, 21 S. Court 128, 45 L. ed. 186, 1900, Twining v. New Jersey, 211 U.S. 78, 97, 29 S. Court 14, 53 L. ed. 97, 1908, as listed in the case of United States v. Guest, 383 U.S. 745, 86 S. Court 1170, 16 L. ed. 2d. 239, 1968, a case involving criminally prosecuting people for obstructing the right. Obstruction is a federal crime pursuant to Federal Criminal Law 18 U.S.C. Section 241. Therefore, obstructing a right is a crime under 18 U.S.C. Section 241. Robertson vs. Department of Public Works, freedom of the highways is so old and well established a blessing that we have forgotten the days of the robber barons and toll roads, and yet, under an act like this, arbitrarily administered, the highways may be completely monopolized. If, through lack of interest, the people submit, then they may look to see the most sacred of their liberties taken from them one, by more or less rapid encroachment. Hadfield vs. London, 98 Wash 6571, 168, p.516. Based upon the fundamental ground that the sovereign state has the plenary control of the streets and highways in the exercise of its police power, see police power, infra, may absolutely prohibit the use of the streets as a place for the prosecution of a private business for gain. They all recognize the fundamental distinction between the ordinary right of the citizen to use the streets in the usual way and the use of the streets as a place of business or a main instrumentality of business for private gain. The former is a common right, the latter is an extraordinary use. As to the former, the legislative power is confined to regulation, as to the latter it is plenary and extends even to absolute prohibition. Since the use of the streets by a common carrier in the prosecution of its business as such is not a right but a mere license of privilege. Personal liberty, or the right to enjoyment of life and liberty, is one of the fundamental or natural rights, which has been protected by its inclusion as a guarantee in the various constitutions, which is not derived from, or dependent on, the U.S. Constitution, which may not be submitted to a vote and may not depend on the outcome of an election. It is one of the most sacred and valuable rights, as sacred as the right to private property, and is regarded as inalienable. 16 CJS, Constitutional Law, Sect.202, p.987. 2 M. Ure. First, Constitutional Law, Sect.329, p.1135. This does not say, as a passenger. Personal liberty largely consists of the right of locomotion to go where and when one pleases, only so far restrained as the rights of others may make it necessary for the welfare of all other citizens. The right of the citizen to travel upon the public highways and to transport his property thereon, by horse-drawn carriage, wagon, or automobile, is not a mere privilege which may be permitted or prohibited at will, but the common right which he has under his right to life, liberty, and the pursuit of happiness. Under this constitutional guarantee one may, therefore, under normal conditions, travel at his inclination along the public highways or in public places, and while conducting himself in an orderly and decent manner, neither interfering with nor disturbing another's rights, he will be protected, not only in his person, but in his safe conduct. Page 17 of 33. Personal liberty consists of the power of locomotion, of changing situations, of removing one's person to whatever place one's inclination may direct, without imprisonment or restraint unless by due process of law. 1 Blackstone's Commentary 134, Hare, Constitution. 777, Bouvier's Law Dictionary, 1914 ed., Black's Law Dictionary, 5th ed. Again, this does not say, as a passenger. The right to locomotion, the ability, means, and use by which to travel, an element of liberty, was so highly protected that it ranked next to the protection from murder, an element of life, such that if one were to deprive another of their very means of travel, such as their horse, the thief was often summarily executed, frequently by hanging. Such recognition did not require codes of statutes. That recognition predated all forms and fictions of government. Justice Tallman was concerned about the state prohibiting the citizen from the most sacred of his liberties, the right of movement, the right of moving one's self from place to place without threat of imprisonment, the right to use the public roads in the ordinary course of life. When the state allows the formation of a corporation, it may control its creation by establishing guidelines, statutes for its operation, charters. Corporations who use the roads in the course of business do not use the roads in the ordinary course of life. There is a difference between a corporation and an individual. As stated by the United States Supreme Court in Hale v. Henkel 201 U.S. 43. This is what the courts have to say about probable cause and police powers. Police power extends only to immediate threats to public safety, health, welfare, etc. Michigan v. Duke 266 U.S. 476 led. At 449, which driving and speeding are not. California v. Farley CED. RPT. 89, 20 CA 3D 1032 1971, the U.S. Supreme Court, in Scheuer v. Rhodes, 416 U.S. 232, 94 S. Court. 1683, 1687, 1974 stated that, when a state officer acts under a state law in a manner violative of the federal constitution, he comes into conflict with the superior authority of that constitution, and he is in that case stripped of his official or representative character and is subjected in his person to the consequences of his individual conduct. The state has no power to impart to him any immunity from responsibility to the supreme authority of the United States. Consider the mandate of codes to compel one to assist the police in their pursuit to find some issue which can and will be misrepresented so as to be used against that party. Such mandates violate the constitutional protection against being compelled to assist in producing information. The word is witness, not incriminate, and to remain silent where your words can and will be used against you, and to imply consent. Having a virtually unlimited access to personal information with the use of computers, police have access to unverified information in their objective to find just about anything which can and will be used against any lesser equipped and financed individual. The practice of accepting official data as factual goes against the mandate of law, where one must be provided the opportunity to cross-examine the source of any and all information which might be detrimentally used against one in a court proceeding. All computers can be hacked. New Jersey Statute, NJSA. 40A, 14-152, as well as similar statutes around the country, expressly forbids police officers from arresting people in civil causes. Police officers shall have the power to serve and execute process issuing out of the courts having local criminal jurisdiction in the municipality, and shall have the powers of a constable in all matters other than in civil causes arising in such courts. State, county and/or municipal law enforcement officers are only empowered to act for the arrest, detection, investigation, conviction, detention or rehabilitation of persons violating the criminal laws of the state. Pursuant to NJSA. 40A, 14-152.2 states, State v. Allen, 335 So. 2D 823825 Florida, 1976, page 18 of 33. It is a fundamental principle of law that no person be adjudged guilty of a crime until the state has shown that a crime has been committed. The state therefore must show that a harm has been suffered of the type contemplated by the charges, for example, a death in the case of a murder charge or a loss of property in the case of a theft charge, and that such harm was incurred due to the criminal agency of another. Thus, it is sufficient if the elements of the underlying crime are proven rather than those of the particular degree or variation of that crime which may be charged. The subject warrant is not a legitimate warrant or a legitimate exercise of judicial power. New Jersey Statute, NJSA 40A, 14-152, as well as similar statutes around the country, expressly forbids police officers from arresting people in civil causes. Police officers shall have the power to serve and execute process issuing out of the courts having local criminal jurisdiction in the municipality and shall have the powers of a constable in all matters other than in civil causes arising in such courts. State, county and/or municipal law enforcement officers are only empowered to act for the arrest, detection, investigation, conviction, detention or rehabilitation of persons violating the criminal laws of the state. Pursuant to NJSA 40A, 14-152.2 states, as used in this section, law enforcement officer means any person who is employed as a permanent full-time member of any state, county or municipal law enforcement agency, department, or division of those governments who is statutorily empowered to act for the detection, investigation, arrest, conviction, detention, or rehabilitation of persons violating the criminal laws of this state and statutorily required to successfully complete a training course approved by, or certified as being substantially equivalent to such an approved course, by the Police Training Commission pursuant to PL 1961, c. 56 c. 52-17b 66 et seq. Law enforcement agency means any public agency, other than the Department of Law and Public Safety, any police force, department or division within the state of New Jersey, or any county or municipality thereof, which is empowered by statute to act for the detection, investigation, arrest, conviction, detention, or rehabilitation of persons violating the criminal laws of this state. The law is clear. Arresting someone in a civil matter is unconstitutional and unlawful, notwithstanding a fraudulent order for arrest warrant issued by purported administrative ministerial officers allegedly acting as judges, aka JMC. Note, Title 39, aka the Motor Vehicle Code, has never been passed as a lawful criminal statute or code. In order to satisfy the requirements of the Fourth Amendment, an arrest must be supported by probable cause to believe that a crime has been committed. Probable cause can only exist in relation to criminal conduct. It follows that civil disputes, civil matters cannot give rise to probable cause. Over 30 years ago, the United States Supreme Court warned of the danger and the threat to liberty if the requirement of probable cause is not strictly abided by. Wong Sun v. United States, 371 U.S. 471, 479, 9 L.ed., 2d 441, 83 S. Court. 407 1963, the history of the use, and not infrequent abuse of the power to arrest cautions that a relaxation of the fundamental requirements of probable cause would leave law-abiding citizens at the mercy of the officer's whim or caprice. Quote, "If a person is arrested on less than probable cause, the United States Supreme Court has long recognized that the aggrieved party has a cause of action under 42 U.S.C. Section 1983 for violation of Fourth Amendment rights." Pearson v. Ray, 386 U.S. 547, 87 S. Court. 1213 1967. Law enforcement officers cannot claim objective reasonableness in these actions. The law is clearly established regarding arresting and imprisoning a person in a civil debt matter where there is no probable cause. Page 19 of 33. Remember, probable cause equals evidence of a criminal action equals actual damage to a property or a right. Fictions have no rights since fictions can be terminated at any time by those who have created them. In Schneider v. Simonini, the New Jersey Supreme Court set the standard for probable cause. It shows us that probable cause to arrest requires a showing that both a crime has been, or is being committed, and that the person sought to be arrested committed the offense. Schneider v. Simonini, 749 A2D 336, 163 NJ 336, at 363 2000. It was further held that a probable cause determination could only be made if a warrant had a supporting affidavit, as supplemented by sworn testimony before the issuing judge that is recorded contemporaneously. ID. At 363. New Jersey District Court cases and other nearby district courts, Santiago v. City of Vineland, 107 F. Sup. 2D 512, 561–62, 564 DNJ 2000, Hill v. Alger, 85 F. Sup. 2D 391, 397–98 DNJ 2000. Arrest made without probable cause violates the Fourth Amendment. Schneider v. Simonini, 749 A2D 336, 163 NJ 336, 361–65 2000 provided a detailed explanation of probable cause standard in New Jersey. New Jersey Constitution, Article 1, Paragraph 13, no person shall be imprisoned for debt in any action, or on any judgment founded upon contract. The Supreme Court of New Jersey takes this point one step further in State v. Madewell, 63 NJ 506, 512 1973, statutes or ordinances, designed as debt-collecting devices under the guise of penal laws, contravene the constitutional prohibition against imprisonment for debt. Thus, the legislature may not circumvent the prohibition by rendering criminal a simple breach of contract, the non-payment of debt, or the failure to use one's own money for a purpose other than for payment of debts. However, statutes against false pretenses, frauds, cheats, and the like, are sustained as against the constitutional objection that such statutes impose imprisonment for debt, on the theory that one who violates the act is punished for the crime he has committed, although civilly the acts may also constitute a breach of contract or the non-payment of a debt. 16 CJS Constitutional Law, Section 204 p.1011. Bold, underline and italics added pursuant to the September 1998 amendment to N.J. Court Rule, R-110-3, 2002 Gann edition. Comment: the evident purpose of this amendment is to make clear that enforcement by incarceration was never intended to create a so-called debtor's prison. No municipal court in New Jersey or any other state can be unbiased because they have a financial conflict of interest in the outcomes of penal code awards, collections and enforcement of same. That conflict of interest involves the federal reimbursement and incentive funding to the state for the enforcement and collection in order to maximize the funding they receive from the federal government to fill their treasuries and to supplement judicial and state employee pension plans. The more penal code penalties awarded, collected and enforced upon, the more federal funding the state receives. It therefore behooves state municipal court administrative, ministerial officers, aka judges, to award as much as possible, notwithstanding the true costs of criminalizing people. This fictitious imposing of penal penalties obligations based on a fraudulent sentencing guidelines designed by judges, and those who are supporters, advocates and bureaucrats of peonage, creates a fraudulent presumption and conflict of interest. Once this funding is paid to the state, based on overinflated peonage awards and collections, it is then forwarded to the general treasury and subsequently into the pension plans of judges, sheriffs and sheriff's deputies, law enforcement officers, politicians and other public servants. Page 20 of 33 Court's jurisdiction not enlarged by police authority. The jurisdiction of the court is limited to protecting rights. This is not enlarged by alleging the police have authority to issue tickets and to arrest people. Such authority does not work to trump fundamental limitations on the courts. U.S. v. Bink, 74 F. Sup. 603 1947 jurisdiction, in criminal cases, is never conferred by implication and cannot be enlarged by any mere inferences from the law or by doubtful construction of its terms. If the record does not show upon its face the facts necessary to give jurisdiction, they will be presumed not to have existed. Norman v. Zeber. A distinction must be here observed between excess of jurisdiction and the clear absence of all jurisdiction over the subject matter any authority exercised as a usurped authority, and for the exercise of such authority, when the want of jurisdiction is known to the judge, no excuse is permissible. Bradley v. Fisher, 13 Wall 335, 351, 352. We have no more right to decline the exercise of jurisdiction which is given than to usurp that which is not given. The one or the other would be treason to the Constitution. Cohen v. Virginia, 19 U.S. 264. Seizures are many times done under letters of marque in reprisal, i.e. recapture. C. 31 U.S.C. A 5323. Such principles as fraud and justice never dwell together, Wingate's Maxims 680, and a right of action cannot arise out of fraud. Broom's Maxims 297, 729, Cowper's Reports 343, 5 Scott's New Reports 558, 10 Mass. 276, 38 Fed. 800, are too high of a though concept, as is due process, just compensation, and justice itself. Honor is earned by honesty and integrity, not under false and fraudulently pretenses, nor will the color of the cloth one wears cover up the usurpations, lies, trickery and deceits. When black is fraudulently declared to be white, not all will live in darkness. E.g. as when an officer testifies that failing to use a turn signal is a criminal act with support of the JMC. When enforcing mere statutes, judges of all courts do not act judicially and thus are not protected by qualified or limited immunity. C. Owen v. City, 445 U.S. 662, both Key v. Terry, 713 F2D 1404, but merely act as an extension as an agent for the involved agency, but only in a ministerial and not a discretionary capacity. Thompson v. Smith, 154 SE 579, 583, Keller v. P.E., 261 U.S. 428, FRC v. G.E., 281, U.S. 464. Immunity for judges does not extend to acts which are clearly outside of their jurisdiction. Bowers v. Heisel, C.A. N.J. 1966, 361 F2D 581, Cert. Den. 87 S. Court. 1367, 386 U.S. 1021, 18 L. ed. 2D 457. See also Muller v. Wachel, DCNY 1972, 345 F. Sup. 160, Rhodes v. Houston, D.C. Nebraska. 1962, 202 F. Sup. 624 affirmed 309 F2D 959, Cert. Den 83 Street 724, 372 U.S. 909, 9 L. ed. 719, Cert. Den 83 S. Court. 1282, 383 U.S. 971, 16 L. ed. 2nd 311, motion denied 285 F. Sup. 546. When acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts in administering or enforcing statutes do not act judicially, but merely ministerially. Thompson v. Smith, 154 SE 583. A judge ceases to sit as a judicial officer because the governing principle of administrative law provides that courts are prohibited from substituting their evidence, testimony, record, arguments, and rationale for that of the agency. Additionally, courts are prohibited from substituting their judgment for that of the agency. Courts in administrative issues are prohibited from even listening to or hearing arguments, presentation, or rationale. ASISV, U.S., 568 F2D 284. Government immunity. In Land Court noted, that when the government entered into a commercial field of activity, it left immunity behind. Brady v. Roosevelt, 317 U.S. 575, FHA v. Burr, 309 U.S. 242, Kiefer v. RFC, 306 U.S. 381. As when the prosecution refuses to provide complete discovery and proof of jurisdiction on the record and the ministerial officer, aka JMC, assists in support of that refusal, constitute an obstruction of justice. Page 21 of 33 Rubenstein v. Collins, 20 F3D 160, 1990, failure to disclose material information necessary to prevent a statement from being misleading, or making representation despite knowledge that it has no reasonable basis in fact, are actionable as fraud under law. Allen v. Wright, 468 U.S. 737, 750–751. Huberman v. Public Power Supply System, 744 P2D 1032, 1055. The doctrine of standing prohibits a litigant state from raising another's legal rights. As when JMC asserts his choice is reserved exclusively to the accused. High Tide Seafoods v. State, 725 P2D 411, 415 1986. If a plaintiff state lacks standing to bring a suit, courts lack jurisdiction to consider it. Standing precedes jurisdiction. Kucera v. State, Department of Transp. 995 P2D 63. Injury in fact element of standing is satisfied when a plaintiff alleged the challenged action will cause a specific and personal harm. State is a fiction and cannot be injured absent a contract. Haberman v. Washington Public Power Supply System, 744 P2D 1032. Doctrine of standing prohibits the litigant state from raising another's legal rights. Therefore, according to the doctrine of standing, the state, aka prosecutor's name must allege the violation of his own legal right, loss or harm, and is prohibited from raising another's rights. Constitutional standing requires the plaintiff to show that the conduct of which he complains has caused him to suffer an injury in fact that a favorable judgment will redress. Id. at 12. In comparison, prudential standing encompasses the general prohibition on a litigant's raising another person's legal rights. Id. Citation and quotation omitted, see also Oregon v. Legal Serves. Corp. 552 F3D 965, 971 9th CIR. 2009. Chapman v. Pier 1 Imports US. Inc., 631 F3D 939954 9th CIR. 2011. Standing is a requirement grounded in Article 3 of the United States Constitution, and a defect in standing cannot be waived by the parties. People v. Superior Court 2002. Standing is typically treated as a threshold issue, in that without it no justiciable controversy exists. As a general principle, standing to invoke the judicial process requires an actual justiciable controversy as to which the complainant has a real interest in the ultimate adjudication because he or she has either suffered or is about to suffer an injury. In New Jersey, the practice, when jurisdiction is challenged, is for the court to proceed as if no one has spoken absent any and all legal standing. Silence can only be equated with fraud where there is a legal or moral duty to speak, or where an inquiry left unanswered would be intentionally misleading. We cannot condone this shocking behavior. This sort of deception will not be tolerated, and if this is routine it should be corrected immediately. US v. Tweal, 550 F2D 297, 299. See also US v. Pruden, 424 F2D 1021, 1032, Carmen v. Bowen, 64A 932. This is what the courts have to say about crime, no corpus delicti. The corpus delicti is the body of the crime itself. Virtually every American jurisdiction agrees it's an absolutely essential element of any crime and is consistent with the stated purpose of American governments. State v. Smith, corpus delicti is usually proven by following two elements, injury or loss, and someone's criminal act as cause thereof. Page 22 of 33. State v. Espinoza, corpus delicti consists of injury or loss and someone's criminal act which caused it. People v. Sapp, 73 P3D 433, 467 Cal. 2003. Quoting People v. Alvarez, 2002-27 Cal. 4th 1161, 1168-1169, 119 Cal. RPTR, 2D 903, 46 P3D 372. Caliph. In every criminal trial, the prosecution must prove the corpus delicti, or the body of the crime itself, i.e., the fact of injury, loss or harm, and the existence of a criminal agency as its cause. Commonwealth v. Maybe, 239 A2D 332, 333. Pennsylvania. The corpus delicti of a crime consists of two elements, 1 the fact of the injury or loss or harm, and 2 the existence of a criminal agency as its cause. Citations omitted. There must be sufficient proof of both elements of the corpus delicti beyond a reasonable doubt. 29A American Jurisprudence 2nd ed., Evidence Section 1476. Because there is no corpus delicti, there is no crime. Yes, there is a so-called crime alleged on paper, but the allegation fails to meet every legal standard of what a crime is. Also, because American governments are established for the sole purpose of protecting rights, a true crime requires the violation of a legal right. Alleged defendant is not accused of violating anyone's legal rights, therefore, there is no crime, case or cause of action plead and the court does not have jurisdiction. The complaint is unfit for adjudication. Because American courts are adversary systems, the complaint is unfit for adjudication. The Supreme Court has found unfit for adjudication any cause that is not in any real sense adversary, that does not assume the "honest and actual antagonistic assertion of rights to be adjudicated." Poe v. Ullman, 367 U.S. 497, 505 1961. Even if the phrase corpus delicti is not used, there is no doubt this is not an adversary proceeding as there are no allegations that one violated any legal rights of plaintiff state. The assigned judge is obligated to take judicial notice and to presume my innocence of every element of the alleged charge, including the element of jurisdiction, until it is proven beyond a reasonable doubt. The judge may not assume the law is applicable now because it is an essential element of the alleged charge. This is what the courts have to say about standing and jurisdiction. As you read the Supreme Court cases, you will find that jurisdiction can be challenged at any time, and in the case of Lopez, it was a jury trial which was declared void for want of jurisdiction. If jurisdiction doesn't exist, it cannot justify conviction or judgment. Without which power, jurisdiction, the state cannot be said to be sovereign. At best, to proceed would be in excess of jurisdiction, which is as well fatal to the state's, U.S.A.'s cause. Broom v. Douglas, 75 Alabama 268-57, so 860. The same being jurisdictional facts fatal to the government's cause, e.g. C. in re FNB, 152 F. 64. If jurisdiction doesn't exist, it cannot justify conviction or judgment, without which power, jurisdiction, the state cannot be said to be sovereign. The United States Supreme Court has clearly, and repeatedly, held that any judge who acts without jurisdiction is engaged in an act of treason. U.S. v. Will, 449 U.S. 200, 216, 101, S. Court. 471, 66 L. ed. 2d 392, 406 1980, Cohens v. Virginia, 19 U.S. 6 Wheat 264, 404, 5 L. ed. 257 1821, Old Wayne Mutt. L. ASSOC, v. McDonough, 204 U.S. 8, 27 South Court. 236 1907, a court cannot confer jurisdiction where none existed and cannot make a void proceeding valid. It is clear and well-established law that a void order can be challenged in any court. Latana v. Hopper, 102 F. 2d 188, Chicago v. New York 37 F. Sup. 150, court must prove on the record, all jurisdiction facts related to the jurisdiction asserted. E.g. a military court must show that one is also in the military before jurisdiction can be perfected. Page 23 of 33. Due process. The requirements of due process must be met before the court can properly assert in personam jurisdiction. Wells Fargo v. Wells Fargo, 556 F. 2d 406, 416. A judgment rendered in violation of due process is void. Worldwide Volkswagen v. Woodson, 444 U.S. 286, 291, National Bank v. Wiley, 195 U.S. 257, Penoyer v. Neff, 95 U.S. 714. Wrights Hidden Lake v. Dist. Court, 183 Colo, 168, 515 p2d 632 1973. Fictions arise from the law and not the law from fictions. Where there is truth, fiction of law exist not. I.e., fictions cannot rule over their creators without consent. Murdoch v. Penn, 319 U.S. 105, 1943. No state shall convert a liberty into a privilege, license it, and attach a fee to it. Miller v. U.S. 230 F. 486, at 489. The claim and exercise of a constitutional right cannot be converted into a crime. I.e., no code or law can compel one to witness against the superior authority of the state and federal constitutions. Brady v. U.S. 397 U.S. 742 at 748, 1970. Waivers of constitutional rights not only must be done voluntarily, they must be knowingly intelligent acts done with sufficient awareness of the relevant circumstances and consequences. Absent coercion in any form, economic or otherwise. City of Dallas v. Mitchell, 245 SW 944. The rights of the individuals are restricted only to the extent that they have been voluntarily surrendered by the citizenship to the agencies of government. As with other states, in California the codes are written so that a verified complaint sworn under oath with 2 signatures is needed to prosecute for most offenses including traffic, misdemeanors, criminal and civil. 99% of the time there is no such complaint because the plaintiff, officer, would have to swear under oath that there was an injured party. In rare occasions such a complaint is issued by crime victims. But neither the district attorney nor the police officer can lawfully issue such a complaint, because they are part of the government fiction, which by definition cannot be injured. Legal fiction, pg 804 Black's 5th edition. Assumption of fact made by court as basis for deciding a legal question. Fiction of law, pg 562. An assumption or supposition of law that something which is or may be false is true, or that a state of facts exists which has never really taken place, as can be seen. State, a fiction at best, is named as plaintiff, but prosecutor is named as the one who comes now and accuses alleged defendant of being in the plaintiff and violating a statute of the state, not the violation of a legal right, loss or harm of his, her own or of the state. Obviously neither the state or the prosecutor is instituting an action in his own name, and there is no plaintiff. Without a plaintiff there can be no case, crime, or cause of action and the court lacks jurisdiction. Even if the absurd claim is made that there is a plaintiff, the plaintiff, state aka prosecutor, still lacks standing. Page 24 of 33 National Organization for Women, Inc., v. Scheidler, 510 U.S. 249. Standing represents a jurisdictional requirement which remains open to review at all stages of the litigation. Allen v. Wright, 468 U.S. 737, 750–751. Huberman v. Public Power Supply System, 744 p2d 1032, 1055. The doctrine of standing prohibits a litigant state from raising another's legal rights. The alleged plaintiff, state, a legal fiction at best, ostensibly acting through cop or prosecutor, cannot properly plead any violation of a legal right or harm. The allegation is of a violation of a statute. By legal definition there is no cause of action. A cause of action is some particular legal right of plaintiff against defendant, together with some definite violation thereof which occasions loss or damage. Lucky v. McCall Manufacturing Co., 152 So, 2d 311, 314. Sewell v. Marden, 452 So, 2d 625, 626. Additional authorities, James Madison's Notes, May 31, 1787, Legislative Intent of Republican Form of Government, the apprehension of the framers in regard to democracy, is exhibited in Madison's Notes May 31, in which Elbridge Gerry and Roger Sherman, delegates to the convention from Massachusetts and Connecticut, urged the convention to create a system which would eliminate the evils we experience, saying that those evils flow from the excess of democracy. The decision of the framers in providing a guarantee to a republican form of government was not an accident, but to intentionally avoid the predictable consequences of direct democracy. Democracy is a factious and intolerant group unbound by oath to support and defend our constitutional system. James Madison, Federalist Paper No. 62. Laws must be few, understandable, and stable. The internal effects of immutable policy are still more calamitous. It poisons the blessings of liberty itself. It will be of little avail to the people that the laws are made by men of their own choice if the laws be so voluminous that they cannot be read, or so incoherent that they cannot be understood, if they be repealed or revised before they are promulgated, or undergo such incessant changes that no man, who knows what the law is today, can guess what it will be tomorrow. Law is defined to be a rule of action, but how can that be a rule, which is little known, and less fixed? Another effect of public instability is the unreasonable advantage it gives to the sagacious, the enterprising, and the moneyed few over the industrious and uninformed mass of the people. Every new regulation concerning commerce or revenue, or in any manner affecting the value of the different species of property, presents a new harvest to those who watch the change, and can trace its consequences, a harvest, reared not by themselves, but by the toils and cares of the great body of their fellow citizens. This is a state of things in which it may be said with some truth that laws are made for the elite, emphasis mine, few, not for the many individuals, emphasis mine. Justice Brandeis eloquently affirmed his condemnation of abuses practiced by government officials, who were defendants, acting as government officials. In the case of Olmsted v. US 277 US 438-48, South Connecticut. 564, 575, 72 L. ed. 944 1928. He declared, "Decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are the commands to the citizen. In a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. Crime is contagious. If the government becomes a law breaker, it breeds contempt for the law, it invites every man to be a law unto himself. It invites anarchy. To declare that, in the admission of the law, the end justifies page 25 of 33 the means would bring a terrible retribution. Against that pernicious doctrine, the court should resolutely set its face. As we watch today, we see the effects of lawlessness states and cities in the ever-increasing violence by those representing the democratic socialist left, aka mob rule, while police are being ordered to do nothing by their lawless administrations. It is for that reason that proof of jurisdiction is required to be entered on the record, before a court is permitted to proceed. While government may have jurisdiction over its creations and those who have relinquished their sovereignty, such claims of jurisdiction do not extend beyond those limits. Particularly in cases arising out of civil, aka contractual, matters. People can exist absent government, but government cannot exist absent people no more than a dream can exist absent the dreamer. The dreamer can dream alone, but government cannot exist alone or even as a creation of only one individual. Definitions: specific performance, an extraordinary equitable remedy that compels a party to execute a contract according to the precise terms agreed upon or to execute it substantially so that, under the circumstances, justice will be done between the parties. Defenses: a contract that is unenforceable because it has not complied with the Statute of Frauds, an Old English law, adopted in the United States, that requires certain contracts to be in writing, cannot be enforced through specific performance. Laches is an equitable defense, matter asserted to diminish a plaintiff's cause of action or to defeat recovery, that prevents the enforcement of a contract by specific performance. Laches is an unreasonable delay in asserting a right with the result that its enforcement would cause injury, prejudice, or disadvantage to others. Laches is applied only where enforcement of a right will cause injustice. The doctrine of clean hands is a defense in an action for specific performance. As explained in the discussion of the case of Charles Flowers, a court will deny specific performance if the plaintiff has acted in bad faith or fraudulently in the same transaction for which he is seeking relief. A contract might not be specifically enforced if, as a result of superior bargaining power, the plaintiff takes unfair advantage of the defendant who is in a debilitated position. This situation transpires when the consideration, the inducement to enter into a contract, is so inadequate as to shock the conscience, or when sharp dealings are involved, such as where the defendant is ill. Failure to disclose material facts to the defendant that, if revealed, would have prevented a contract from being made is a ground to deny specific performance. Mistakes and misrepresentations in the terms of a contract might constitute a defense against specific performance. If such mistakes are sufficient to justify rescission of a contract, they are sufficient to prevent the enforcement of the contract. A court will enforce only a contract with definite and certain terms. Exceptional circumstances barring specific performance, the award of specific performance is never a guarantee. There exist exceptional circumstances barring specific performance, which influence a court's decision. An order of specific performance is generally not granted if any of the following is true: 1. Specific performance would cause severe hardship to the defendant. 2. The contract was unconscionable. Quasi-criminal. 3. Common law damages are readily available or the detriment suffered by page 26 of 33 the claimant is easy to substitute, then damages are adequate. Debtor's prison? 4. The claimant has misbehaved, unclean hands, imposed impossible conditions. 5. Specific performance is impossible. 6. Performance consists of a personal service. Debtor's prison? 7. The contract is too vague to be enforced, commercial, civil, quasi-criminal. 8. The contract was terminable at will, meaning either party can renege, suspend, without notice. Note that consumer protection laws may disallow terms that allow a company to terminate a consumer contract at will, e.g. unfair terms in Consumer Contracts Regulations 1999. The contract required constant supervision. 9. Mutuality was lacking in the initial agreement of the contract. 10. The contract was made for no consideration. 11. Specific performance will not be granted for contracts which are void or unenforceable. 12. Plaintiff has superior bargaining power, taking unfair advantage of the defendant who is in a debilitated position. Debtor's prison? Peonage, American English, in a historical and legal sense, peon generally referred to someone working in an unfree labor system known as peonage. The word often implied debt bondage or indentured servitude. Peonage, P-A-N-I-J, noun, 1. In Spanish America, a farm worker or unskilled laborer, day laborer. 2. Formerly, especially in Mexico, a person held in servitude to work off debts or other obligations. 3. Any person of low social status, especially one who does work regarded as menial or unskilled, drudge. Noun, 1. The condition or service of a peon. 2. The practice of holding persons in servitude or partial slavery, as to work off a debt or to serve a penal sentence. Related words: serfdom, enslavement, bondage, subjugation, labor, servitude, captivity, yoke, thraldom, thrall, obedience, confinement, subjection, bonds, vassalage, enthrallment, restraint, work, grind, drudgery, also known as debt bondage or debt slavery. It is the most common form of modern slavery. Despite this, it's the least known. Debt bondage occurs when a person is forced to work to pay off a debt. They are tricked into working for little or no pay, with no control over their debt. The use of penal codes to compel involuntary servitude under a process known as peonage, aka penal statutes, where people are contractually criminalized, in order to circumvent the constitutional prohibition against slavery. Why just enslave the black community when the entire nation can be enslaved under a system of peonage, aka penal codes previously known as the Black Codes, aka Specific Performance Codes, aka the Tax, Motor Vehicle Codes, Environmental Codes, and many, many more. 13th Amendment to the U.S. Constitution, Abolition of Slavery. The House Joint Resolution proposing the 13th Amendment to the Constitution, January 31, 1865, Enrolled Acts and Resolutions of Congress, 1789–1999, General Records of the United States Government, Record Group 11, National Archives. Page 27 of 33, passed by Congress on January 31, 1865, and ratified on December 6, 1865. The 13th Amendment abolished slavery in the United States and provides that neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States, or any place subject to their jurisdiction. New Jersey Constitution, Article 1, Paragraph 13, no person shall be imprisoned for debt in any action, or on any judgment founded upon contract. Pursuant to the September 1998 amendment to N.J. Court Rule, R-110-3, 2002 Gann edition, comment, the evident purpose of this amendment is to make clear that enforcement by incarceration was never intended to create a so-called debtor's prison. The motor vehicle codes are referred to as being quasi-criminal codes compelling specific performance. What these terms are defined as specific performance, an extraordinary equitable remedy that compels a party to execute a contract according to the precise terms agreed upon or to execute it substantially so that, under the circumstances, justice will be done between the parties. Specific performance grants the plaintiff what he actually bargained for in the contract rather than damages, pecuniary compensation for loss or injury incurred through the unlawful conduct of another for not receiving it. Thus specific performance is an equitable rather than legal remedy. By compelling the parties to perform exactly what they had agreed to perform, more complete and perfect justice is achieved than by awarding damages for a breach of contract. Note, in order to compel specific performance, a contract must first be in place. Quasi, kwz, quas combining form seemingly, apparently but not really. Quasi-American, more, synonyms, supposedly, seemingly, apparently, allegedly, reportedly, professedly, ostensibly, on the face of it, to all appearances, on the surface, to all intents and purposes, outwardly, superficially, purportedly, nominally, by one's, its own account, on paper, pseudo-pretendedly, ostensively, supposed, seeming, apparent, alleged, reported, ostensible, purported, nominal, so-called, would-be, pseudo-bogus, sham, phony, imitation, artificial, mock, ersatz, fake, forged, feigned, pretended, simulated, false, spurious, counterfeit, fraudulent deceptive pretend put on fakey cod ostensive quasi-criminal. Wikipedia. Quasi-criminal means a lawsuit or equity proceeding that has some, but not all, of the qualities of a criminal prosecution. It may appear in either a common law or a civil law jurisdiction. It refers to a court's right must be derived from a valid contract to punish for actions or omissions as if they were criminal. The origins of the phrase comes from the Latin language word quasi, meaning somewhat, sort of, alike or akin, to criminal law, as in quasi-contract. Quasi is used to indicate that one subject resembles another, with which it is compared, in certain characteristics, but there are intrinsic and material differences between them. During a civil or equity trial, a court may act as if it were a criminal case to punish a person for contempt of court. In some cases, a court may impose asset forfeiture or another penalty. For page 28 of 33 example, a court has the right to punish actions or omissions of a party in a child support case as if they were a criminal, penalizing the parent with a sentence of jail time. The part attorneys leave out is the requirement for a contract to be in place first, always to their own financial and political benefit. Unconscionable, unconscionable, n-conch, nbl, adjective, unconscionable not right or reasonable. Being forced to get a license so that one could sent to jail for not using a turn signal is unconscionable. Synonyms: unethical, amoral, immoral, unprincipled, indefensible, wrong, unscrupulous, unfair, underhand, dishonorable, dishonest, corrupt, depraved, fraud, an intentional perversion of truth for the purpose of inducing another in reliance upon it to part with some valuable thing belonging to him or to surrender a legal right, a false representation of a matter of fact, whether by words or by conduct, by false or misleading allegations, or by concealment of that which should have been disclosed, which deceives and is intended to deceive another so that he shall act upon it to his legal injury. Black's Law Dictionary. Habeas corpus, New Jersey State Constitution 1947, updated through amendments adopted in November 2003. Article 1. Rights and privileges. 1. All persons are by nature free and independent, and have certain natural and unalienable rights, among which are those of enjoying and defending life and liberty, of acquiring, possessing, and protecting property, and of pursuing and obtaining safety and happiness. 2. A. All political power is inherent in the people. Government is instituted for the protection, security, and benefit of the people, and they have the right at all times to alter or reform the same, whenever the public good may require it. 7. The right of the people to be secure in their persons, houses, papers, and effects, against unreasonable searches and seizures, shall not be violated, and no warrant shall issue except upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the papers and things to be seized. 13. No person shall be imprisoned for debt in any action, or on any judgment founded upon contract, unless in cases of fraud, nor shall any person be imprisoned for a militia fine in time of peace. 14. The privilege of the writ of habeas corpus shall not be suspended, unless in case of rebellion or invasion the public safety may require it. 20. Private property shall not be taken for public use without just compensation. Individuals or private corporations shall not be authorized to take private property for public use without just compensation first made to the owners. Constitution of the United States of America, Article 1, Section 9, Paragraph 2, the privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. Page 29 of 33. How state constitutions are written to fool people so government can expand its power and reach, submitted by M. R. Hamilton on Wednesday, August 19, 2015. 1913. Many people depend on their state constitutions for protection against government overreach. People misperceive that something in their state constitution grants their state governments authority over said people. However, once people learn to differentiate between people and persons, it becomes much easier to tell which part of the Constitution may apply to him, her, them, and which applies to other persons. One of the things to look for when reading a constitution is whether or not a phrase is limiting government or granting government authority. When reading any constitution, one will soon see that when government is being limited, the section or clause will be discussing people. When granting government authority, the section of clause will be referring to persons. So how can we confirm that there is a difference between a people and a person? Well, let us read Section 9 of the Texas Constitution, which states, searches and seizures. The people shall be secure in their persons, houses, papers and possessions, from all unreasonable seizures or searches, and no warrant to search any place, or to seize any person or thing, shall issue without describing them as near as may be, nor without probable cause, supported by oath or affirmation. Here we see that a person is something that can be owned by a people. Must be some truth to the matter about there being a difference. Actually, the term person refers to the legal substance of an individual. An individual can be a people, but a person can also be a corporation, a trust, which is a type of corporation, a town, a city, a county, or even a state, and the state's corporation like the state of Texas. Just read any sign, statute or regulation and it become abundantly clear. People are not subject to government rule. Persons can be if they are not people. Just read the HOV signs on the highway that say, 2 or more persons. Any regulation will state no person or all persons. They never say no people or all people, because government has not authority to tell people what to do. If it ever does, always challenge government jurisdiction. Summary: the intent of the legislators constitutes the law. Stewart v. Conn, 11 Wall. 78 U.S. 493, 504. Our system of government is specifically designed to strongly limit the reach and power of our governments to invade our rights and freedoms. Our founding fathers went to great lengths to put in checks and balances to prevent one group of people from acquiring the power and reach to command all other groups of people. What we are finding out now is how there have been many who have been quietly working behind the scenes to acquire authority, power, and to undermine those protections. In New Jersey, Title II-C is the only criminal code for the state. Title 39 is the motor vehicle code, and if the legislators wanted Title 39 to be a criminal code, it would have been placed in the criminal code, not separate. The intention of the legislators was to use Title 39 as an instrument to regulate the commercial use of the roads within the state of New Jersey. The term used to define that process as specific performance. The sovereignty of any state only extends over other fictions of law and never over natural people who are sovereign over the state fiction created by the people. Motor vehicle codes are commercial, contractual codes and as such require a validly executed contract to be in place before the specific performance terms of those contracts can be compelled. Page 30 of 33. Municipal courts are administrative agencies as defined due to their statutory enforcement character. By law, the judges descend to the role of ministerial officers and are therefore prejudiced to their own advantage, as can be observed by their daily activities. The requirement of there being proof of jurisdiction on the record is designed to prevent those parties who are not subject to the jurisdiction of those municipal corporations to not suffer injury at their hand. This prohibition is routinely violated at a great profit by those criminal enterprises. Proof of jurisdiction was repeatedly demanded at all stages of the proceedings before Ministerial Officer M.J. Nemeth, aka JMC. Each demand was met with a statement that Ministerial Officer M.J. Nemeth, aka JMC, had already decided that he had jurisdiction and the matter was therefore closed. When discovery was demanded from Prosecutor D.A. Alsafrum, he flatly denied any and all discovery materials existed and refused to provide Brady materials, arrogantly stating, "I do not answer questions, I ask them." June 24, 2019. OFR Johnson did perjure himself, with the assistance of Prosecutor D.A. Alsafrum, Public Def B.D. Putterman, and Ministerial Officer M.J. Nemeth, aka JMC, when he stated that a failure to use a turn signal constituted a criminal act. OFR Johnson was also assisted in covering up his falsifying evidence with assistance of Prosecutor D.A. Alsafrum, Public Def B.D. Putterman, and Ministerial Officer M.J. Nemeth, aka JMC, when they dismissed all tickets which were known at the initial encounter to be false and refused them to be used as evidence. Tickets were issued for no registration, false, no insurance, false, no seat belt, medical exemption, no turn signal, false. And any and all questions to those false tickets were blocked from displaying the use of police powers to generate revenue for that municipality. Victim has manuals which younger brother used to qualify as a patrolman from the Seagirt police training facility, where that brother was taught how to escalate a common traffic stop into a more profitable one. Ministerial Officer M.J. Nemeth, aka JMC, corruptly declared a decision of guilty, giving 20 days for appeal while immediately instructing 2 officers to place his victim in jail, lacking proof of his jurisdiction. Now, this begs the questions: if one successfully appeals that decision, how does one get that life restored? Another point is that in jailing victim, Ministerial Officer M.J. Nemeth, aka JMC, is thumbing his nose at any and all appellate courts, i.e., you might reverse me but I will have had the last F.U. on all of you. Additionally, the following day another victim was convinced by prosecutor D.A. Alsafrum to not avail himself of a public defender as things would be easier for him to get a reduced sentence. Not so as it turned out. Little did they know that two of their victims would meet and compare notes. The first victim was forced to have ineffective counsel chosen by Ministerial Officer M.J. Nemeth, aka JMC, while the second victim was denied counsel of any kind. He was given 90 days for stealing food. Within a day a writ of habeas corpus was presented to the jail requiring the signature of the first victim. The carrier was turned away with the explanation that such documents cannot be presented for signature and must be sent by mail. That same habeas corpus was then sent by mail, opened, obviously read, and summarily refused with a letter falsely stating that the article did not have a return stamped false envelope false and that it was not material which was allowed. Recent copies of letters to state sheriff's departments have only reinforced the already known fact that those who rule New Jersey are engaged in a criminal enterprise designed to endanger those who are trying to fight crime and not try to turn everyone else into criminals for the sake of money and power. Page 31 of 33 Conclusions? So what are we to conclude from all of that? Well, first we must use the words we have learned to ask some very pointed questions. What do we call states and cities who have declared themselves to be sanctuary states and cities, aka above the law? We have heard so much about Russia trying to influence our elections. To that, why do we fear such an influence? After all, the Democratic presidential candidates are making promises which can be quoted directly out of the 1936 Democratic Constitution of the USSR former. Perhaps for the same reason that the National Workers' Socialist Party (Nazi) of pre-World War II Germany hated the Communist Party, they did not want to share their plunder with Moscow. What do we call those in positions of power who are using their power to flood our nation with foreign national who are only here to drink from the finite well of benefits we have created for our own people and be cleverly added to our voter rolls aided with hiding the true number of non-citizens in the country? What do we call politicians who seem to believe that they can squeeze blood from a stone, as I have witnessed a JMC in Haddon TWP Municipal Court command an old woman, on a fixed income, be told that she had to come up with the fines and fees he was profiting from, even if she had to sell all of her possessions, with him knowing that she could barely afford the money to eat, much less have the money for insurance and repairs to her broken water system in a house she was not being allowed to barely live in, or face being put in jail. What do we call politicians who command people to buy a product, insurance, which is not only overpriced but which has also created a system prone to refusing to cover what they promised? Having had access to the databases of many insurance companies, buying insurance can be equated to holding a fire bucket with a hole in it and trying to keep it filled. Government insurance is like holding a fire bucket with an even larger hole, bureaucratic overhead, in it while no one is trying to keep it filled as all of the water is being diverted to other places without accountability. Politicians are paid off with speaking fees and such to pass regulations requiring people to buy insurance. In all cases, people are encouraged to play with matches. After all, it is only other people's money. In the early 1960s LBJ created the General Fund and within only 3 years the entire Social Security Trust Fund was emptied as well as the entire Federal Highway Trust Fund. What do we call it when agents of the federal and state governments make themselves unaccountable, aka above that law? What do we call people who put their politics of plunder above the needs of the nation? As when the president vetoed the Civil Rights Act because he wanted agents of government to have immunity over their abuses of power. Fortunately, that veto was overridden and the ensuing debates made it clear that the intent of those laws was to ensure that no one was above the law, particularly all agents of government. What do we call people who are actively engaged in undermining one of the only president who has been putting the people before himself and the deep state bureaucrats, by attempting to reduce their reach and power to diminish and otherwise destroy our economy and accusing him of the very acts they are doing? Cooper v. Anton, 358 U.S. 13, L. ed. 2d 5, 78 S. Court 1401, no state legislator or executive or judicial officer can war against the federal Constitution without violating his oath, taken under Article 6, Clause 3 thereof, to support it, if the legislatures of the several states may at will, annul the judgments of the courts of the United States and destroy the rights acquired under those judgments, the Constitution itself becomes a solemn mockery. The ideal tyranny is that which is ignorantly self-administered by its victims. The most perfect slaves are, therefore, those which blissfully and unawaredly enslave themselves. Charles de Montesquieu, page 32 of 33. I am concerned for the security of our great nation, not so much because of any threat from without, but because of the insidious forces working within, end invisible government based on propaganda, and restore government based upon truth. General MacArthur, even truer today. To none will we sell, to none deny or delay, right or justice. Magna Carta +40. A radical is one who speaks the truth. Congressman Charles A. Lindbergh, Sr. What are we to conclude? Abraham Lincoln stated the following on February 12, 1865, "Our safety, our liberty, depends upon preserving the Constitution of the United States as our fathers made it inviolate. The people of the United States are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who pervert the Constitution. The only thing necessary for the triumph of evil is for good men to do nothing." Edmund Burke, who is out there protecting the public from such excesses of power? President Donald J. Trump. Even while so many are attacking him with fictitious claims, and innuendo devoid of fact and evidence. At the same time, these people are doing the very things they are accusing our president of, such as the left preparing to tamper with our elections by importing as many foreign nationals as they can and doing everything they, the left, can do to undermine our economy with the burden those actions impose, undermining our influence in support of human rights around the world, using a false climate narrative since they, the left, are running out of ways, regulations and taxes to take even more money and property from all people. If you don't know the words, you can't ask the questions. If you can't ask the questions, you will never find the answers. Page 33 of 33.